What rights do owners of unregistered trademarks have? As with copyrights, trademarks do not necessarily have to be registered. Owners of unregistered trademarks have the exclusive right to use the mark in the geographic area where the mark is used. Unregistered trademark holders also have the right to bring civil action against infringers and are protected against false advertising. Unregistered trademarks are usually identified by the TM symbol. What are the benefits of registering a trademark? Additional benefits received by trademarks formally registered with the USPTO include a legal presumption of ownership of the mark, an exclusive right to use the mark nationwide on or in connection with the goods and services listed in the registration, public notice of claim of ownership of the mark, the ability to bring an action concerning the mark in federal court, the use of the U.S. registration as a basis to obtain registration in foreign countries, the ability to record the U.S. registration with the U.S. Customs and Border Protection Service to prevent importation of infringing foreign goods, the right to use the federal registration symbol, listing in the United States Patent and Trademark Office's online databases. Because registration costs money, many small businesses choose to rely upon the common law protections afforded to trademarks. Google, for example, used an unregistered trademark for its first 6 years in operation. The company formally applied for a registered trademark for Google in 2006, which was granted in 2012. But trademark protection can be vital to a small business, as one recent case demonstrates. In 2007, Payam Tabibian first registered the 1950s-style red, white, and yellow logo for his startup, the Z-Burger chain, a few months before he opened his first restaurant. As the New York Times reported, his first restaurant was an immediate hit, attracting students from nearby American University. The place later drew public praise when it gave free food to federal workers who were furloughed from their jobs during government budget cutbacks. But Mr. Tabibian eventually fell out with his partners, who then tried to stop him from continuing to use his Z-Burger brand with his expanding chain of restaurants. They also demanded he transfer the trademarks to them. But because Mr. Tabibian had taken the time to properly register his trademarks, a federal judge ruled in August of 2015 that he was the legitimate owner of the trademarks and could continue to use them. How do you register a trademark? In order for your trademark to be eligible for registration with the USPTO, you must actually use it in conjunction with commercial activity or be about to use it within 6 months. When applying for trademark registration, the applicant must file an affidavit attesting to the date the mark was first used in commerce, as well as a specimen showing how the mark was first used, whether in advertising or on the product in a store setting. It is imperative that the applicant identify the earliest provable date of first use in commerce to lessen the likelihood that another party can claim prior use of that mark and invalidate the trademark. The USPTO also offers an intent to use application, which allows an entity to apply for a trademark that is not yet used in commerce. If you have not yet used the mark but plan to do so in the future, you may file based on a good faith or bona fide intent to use the mark in commerce. A bona fide intent to use the mark is more than an idea, but less than market ready. For example, having a business plan, creating sample products, or performing other initial business activities may reflect a bona fide intent to use the mark. The mark must be put into use within 6 months of receiving a notice of allowance from the USPTO, or the applicant risks having to pay extension fees or losing the mark entirely. If the trademark is still in commercial use 5 years after registration, the owner is eligible to receive an additional protection known as incontestability, protecting it from challenges to validity, ownership, registration, and descriptiveness. How else can trademark value be derived? A trademark can be assigned to others in the event of purchase or acquisition by another entity. There are other reasons why an owner might assign trademarks to another party, including a business name change, a security agreement, a license, a lien as collateral for a loan, or because as a result of a bankruptcy procedure. Ford Motor Company, for example, used its trademarks as collateral for a $23.5 billion loan. Ford was still able to use its trademarks, but if the company had defaulted on the loan, the trademarks would have been assigned to the lender. Trademarks can also be licensed to others. In 2012, licensed trademarks generated $5.45 billion for North American owners, reported the Licensing Industry Merchandisers Association. That same year, the top 150 global brand licensors earned $230 billion in sales of trademarked products. Abandonment of a mark results in loss of ownership and the associated rights of the mark. For a mark to be considered abandoned, it must be discontinued from active use in commerce with no intent to resume the commercial use of the mark. Evidence of non-use for 3 consecutive years is usually considered to be sufficient proof of abandonment. Upon abandonment, the trademark owner loses the right to prevent others from infringing the mark.